Harper Paperbacks and Harper Monahan are proud to present How to Read the Constitution and Why by Kim Wehle. This is an Iliotibial band sleeps reading. Chapter 8, Liberty and Equality, 5th and 14th Amendments. Amendment 5, 1791. No person shall be deprived of life, liberty, or property without due process of law. Liberty has come to mean more than freedom from incarceration. There are two due process clauses. This one applies to the federal government. Amendment 14, 1868. No state shall make or enforce any law which shall abridge the privilege or the immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. What's a privilege or an immunity? This one applies to the states. This is where many of our civil rights come from. For the purposes of this discussion, think of liberty as a person's ability to live life without too much government interference. Liberty is connected to fairness and some version of equality. The Declaration of Independence states that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. But the Declaration of Independence doesn't bind government. You can't put it in your backpack to pull out in court one day if the government goes too far in stomping on your rights. Those rights are, if anywhere, in another document, the Constitution. Many people take for granted that the Constitution ensures blessings of liberty, whatever that might mean to a particular individual. Although undefined, it turns out that the words equal and liberty do appear in the Constitution, but their meanings have fluctuated significantly since the beginning of the Republic. Today, arguments for securing equality of outcomes for all people in American society may be associated with the political left, or even with socialism. Nonetheless, across the political spectrum, there are many things we all freely do, and we all take as a given, that are not expressed in the Constitution. We wouldn't want those rights taken away, whether we happen to be Republicans, Democrats, Socialists, or even anarchists. As residents of one state, for example, we can drive into a neighboring state without the state's troopers harassing us at the border just because we are foreign state citizens. We freely sign contracts for employment, for home ownership, for purchasing goods, all without arbitrary restrictions by federal, state, or local governments. Imagine, by contrast, if people who earned $100,000 or more per year had the privilege of entering into contracts. We get to decide whether and whom to marry without government weigh-in, whether to have children, how to raise those children, and what jobs or careers we choose to have. Imagine if all this were dictated by the government. There is a lot to discuss here. This chapter focuses on four primary themes: race, gender, sexual orientation, and immigration. It asks, how far can the government go in imposing restrictions on men just because they are men? Of course, in real life, this comes up mostly with discrimination against women, but not exclusively. On African Americans, on gays and lesbians. What about immigrants? Do they get rights too? Or can the government do what it pleases with them, like arbitrarily separate mothers from their children at the border and put them in separate prisons with no plan or viable means of reuniting them? Remember that the Constitution cares about the scope of government power, so we need to be cautious in framing issues of equality and fairness under the Constitution about giving people special treatment. Liberty is about containing the government's ability to exercise authority over how we live our lives. If we put more gas in the government's power tank, regardless of who is immediately affected, our own rights necessarily become diminished. Let's review the two constitutional provisions that come into play here. First are the due process clauses, one in the 5th Amendment, which binds the federal government, and one in the 14th Amendment, which binds the states. Bear in mind that neither binds private behavior. The basic idea is that the government can't take away your life, liberty, or property without some kind of process, a hearing at which you get to say your side of the story. The government has the authority to execute you, to take your life, but only if you get a trial first. It can take away your liberty too, but only with a trial or a plea whereby you agree to go to jail. The government can't take your property without a hearing either. For each of these, you get two basic things: a notice of what you allegedly did wrong, and an opportunity to be heard on why you believe the government is wrong to take whatever it's taking away. The concept of due process traces back to King John's Magna Carta, which was a peace treaty struck in 1215 between the king and a group of rebellious barons who had grievances against him. In the Magna Carta, the king made a series of promises to his subjects, including that no free man will be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. The Magna Carta is important because it established the principle that everybody, including the king, is bound by the rule of law. It's a mantra that remains critically important to this day, as President Trump pushes back on virtually any force that seeks to hold him accountable for his actions while president. The Constitution only says that a person gets process if the clauses are triggered. It doesn't define what that process must be. If life or liberty is in question, the process is a full-blown jury trial. Trials are constrained by detailed rules of evidence, which are designed to ensure that juries aren't making decisions based on lying witnesses or falsified documents and the like. They are managed by a neutral decision maker, a judge, who is not allowed to talk privately to either side about the case. That would be unfair. Both sides get to be represented by attorneys if they want, and the losing party gets to appeal to a higher court. The jury trial is the gold standard for process. All the details for ensuring a fair trial, a neutral judge, the ability to cross-examine witnesses, the ability to have your own lawyer, etc., are part of the cluster of elements that make up for the gold standard for process. The government does many things that affect a person's liberty or property in ways that are less drastic than execution or imprisonment, however. Liberty has been construed to include the ability to choose a profession, for example. So if the government wants to take away a doctor's medical license, the doctor gets a hearing because the Constitution says so. There are many additional federal, state, and local laws that overlap with or supplement the Constitution's protection of due process. Those might cover the doctor too, but for our purposes, the question is, what does the boss of all bosses say about what the government can and cannot do to individual liberty, i.e. the Constitution? Property has also been expanded to mean more than just physical objects. The Supreme Court has construed welfare benefits as property. If a person qualifies for benefits under the law, the government can't strip those benefits arbitrarily. Due process requires a hearing. Some people might think that this goes too far, on the theory that welfare benefits are perks at taxpayers' expense, not a constitutional right. That's a fair argument, but it misses the mark. Here again, the question for the Constitution is whether the government has the power to act arbitrarily in ways that impact people's lives, liberty, and property. If the government is going to authorize the receipt of welfare benefits, which it doesn't have to do, it can't then arbitrarily pick and choose who gets them among people who are otherwise equally qualified under the welfare laws. It can't only give benefits to white people, for example, despite the equal qualifications of people of color. As a practical matter, hearings that comply with the Constitution can run the gamut, from a desk decision based strictly on paperwork. Yes, that's a hearing, to a judicial-type proceeding that allows a party to present witness and documents. The more procedures an agency must follow, the more expensive a hearing gets. So the Supreme Court uses a balancing test to determine how much of a procedure is necessary in light of the liberty or property interest at stake. Denials of welfare benefits get more process than denials of disability benefits, for example, although the reasons for the Supreme Court distinction here are sketchy. Although seemingly lofty, the due process clauses can impact everyday life. Imagine that your daughter gets suspended from the University of Maryland because she allegedly cheated on a law school exam, because a law degree is obtained in pursuit of a profession. There is constitutional liberty interest at stake for her. The University of Maryland is an arm of the state, so the Fourth Amendment due process clause applies. She gets a hearing. Suppose you might want to hire the best lawyer in the area for that hearing. The lawyer might want to present a parade of witnesses to testify that your daughter is an honest and trustworthy person, and maybe additional witnesses who were present during the exam to testify that they didn't see her cheat. Maybe the lawyer will also want to present an expert witness to explain the latest research regarding best practices for exam administration, so she can argue to the dean that the school's testing procedures are part of the problem here. Under the balancing test for due process, your daughter might get none of those things. She might get nothing more than the opportunity to draft a letter to the dean giving her side of the story on the rationale that the other things are just too expensive and cumbersome for the school to administer regularly. Or a court might find that more process is warranted because only a few students a month find themselves in this position, so the school can reasonably accommodate the hassle of the additional procedures. If all of this happened at Georgetown University, your daughter would get no process at all unless the school decided to unilaterally give it. Georgetown is a private university, so the process clause doesn't apply. The meaning of due process has expanded beyond mandated hearings. The idea behind what's known as a substantive due process is that certain rights, although not expressed in the Constitution itself, are so central to the concept of liberty that the government cannot get at them regardless of what procedures it uses. Substantive due process includes things like the right to work, the right to marry, and the right to decide how to raise your own children. When these rights are at stake, the government can't interfere with them unless it has a very good reason to. Roe v. Wade, which legalized abortion on the ground that women have the right to make choices about their bodies without the government telling them they can't, is grounded on substantive due process. Like the right to marry and the right to refuse medical treatment, the right to an abortion is not spelled out in the Constitution, but if the Supreme Court were to do away with the concept of substantive due process, a number of other things that we take for granted could later go with it. This is a wrinkle that is rarely discussed when the topic of abortion rights comes around, but it's very important for people trying to understand if they are committed to unraveling Roe. The other position that is important for liberty and equality is the Equal Protection Clause, which provides that no state may deny any person within its jurisdiction equal protection of the laws. Note here that this language says nothing about the federal government treating people equally under the law, nor is there a separate amendment for that purpose, unlike for due process. In an important case decided in 1872, the court fixed this disconnect on both ends by holding that the Due Process Clause applied the First through Eighth Amendments to the states and the federal government alike. An equal protection challenge to a law has 3 steps. The first is that a law has to draw a distinction based on a personal trait. Requiring a person to be 21 years in order to purchase alcohol, for example, is discrimination on the basis of age. The second is that the government's distinction drawing must be for a good enough reason. The first step really matters for the second one. If the distinction or classification is one that we don't want the government drawing distinctions around, then the government has to have a really good reason for it. Race is like that. It gets strict scrutiny. Age discrimination is less of a hot button issue, and enhancing public safety is a good reason for a no teen drinking rule. You get the point. There are a couple of nuances that you might find interesting. Imagine a law that says nobody under the age of 21 can purchase alcohol. But what if the law is written in language that is totally neutral but unfairly affects a certain group of people anyway? Take gender, for instance. What if the same law states that only people who are 5'10" and weigh more than 150 pounds can purchase alcohol? A small percentage of women as compared to men meet this criterion. This law discriminates against women because it's harder for them to purchase alcohol. They need tall friends to do it for them, but the Supreme Court has essentially said too bad. Unless it's shown that the purpose behind the law was to discriminate against women in this hypothetical, there is no equal protection case. As we've seen, when standards require proof of motive or intent, we're climbing into mines again, and it becomes very hard for plaintiffs to win their cases. Additionally, how does the court decide what grading rubric to use? Strict, intermediate, or rational basis scrutiny? Well, as a first cut, it comes down to how a person is born. If the government is discriminating based on immutable characteristics that person has no control over, like race, gender, or what part of the country or world he came from, and whether his parents are married or divorced, then something more than rational basis applies. Race gets strict scrutiny, gender gets intermediate. So assume that we've identified a class that gets protected, step 1, and decided what grading rubric applies, step 2. The third step in the equal protection analysis is that whatever level of scrutiny is applied, a court must decide whether the government's reason for the law are good enough to satisfy the test. Sometimes the answer seems like a slam dunk. In 1942, the Supreme Court applied strict scrutiny to strike down a law that required surgical sterilization of people convicted of 3 or more crimes involving moral turpitude. The court found that the law was about the right to procreate. If you want to have babies, the law basically said that the government will stop you from achieving that goal because the public safety requires that your genetic material be taken out of the gene pool. Not okay. Note that on the other end of the spectrum, it's almost impossible for the government to fail rational basis review. So long as the state can concoct a rational excuse for a law, it will stand. Which means that if something gets rational basis review, the plaintiffs are almost sure to lose their case. New York's law prohibiting physician-assisted suicide was upheld on rational basis review, for example, because it applied equally to everyone. There was no group being singled out. Across all three classifications, the government is more likely to win if it can say that the law is about protecting things like safety and public health. Race. Race may be one of the most important and divisive issues in American life today. And so, full disclosure, this section may contain more than a usual amount of summarizing important cases. Here goes. Prior to the 14th Amendment, the Supreme Court upheld the constitutionality of slavery. In 1793, Congress enacted the Fugitive Slave Act, requiring that captured slaves be returned to their owners. Pennsylvania then passed a law outlawing the use of violence to return slaves. The Supreme Court struck down the Pennsylvania law in 1842, citing the complete right and title of ownership in their slaves as property. The Supreme Court struck down the Pennsylvania law in 1842, citing the complete right and title of ownership in their slaves as property in every state in the Union into which they might escape from the state where they were held in servitude. The court based its ruling on language in Article 4 of the Constitution requiring a person held in service or labor who escapes another state to be delivered up on the claim of the party to whom such service or labor may be due. The original Constitution required that abhorrent result, but the language was overridden by the 13th Amendment slavery ban. In 1819, Congress admitted Missouri into the United States as a slave state and Maine as a free state. The legislation was known as the Missouri Compromise because it was designed to retain the existing balance of power between the North and the South. Part of the deal was that slavery would be prohibited north of the 36 degrees 31 minutes parallel, which was an unorganized territory known as the Great Plains. In a famous case called Dred Scott v. Stanford, the Supreme Court declared the Missouri Compromise unconstitutional because enslaved people were property, not citizens. The government couldn't force people who moved to the Great Plains to give up property that happened to be in the form of human beings. The case involved a man who was taken by his owner to a free state. When the owner died, the man sued the administrator of the estate, seeking his freedom in this free state of Illinois. The court applied to originalist, history-based approach to the case, concluding horrifically that at the time the Constitution was ratified, slaves and even their freed descendants were considered a subordinate and inferior class of beings who had been subjugated to the dominant race, and whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who were held the power and the government might choose to grant them. The 14th Amendment did away with the Dred Scott decision by mandating that all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside. After the Civil War, every southern state passed Jim Crow laws that separated people by race in a wide range of contexts, including public accommodations, transportation, and schools. Private violence against African Americans was rampant too. 3,446 blacks were lynched in the United States from 1882 to 1951. In 1857, Congress passed the first Civil Rights Act, which banned discrimination in private places on accommodations like inns and theaters, but the Supreme Court struck the statute down in 1883, concluding that the 14th Amendment applies only to government action and that Congress cannot regulate private conduct. In 1968, the court ruled that Congress could prohibit discrimination in private parties under the 13th Amendment instead. We already talked about Plessy v. Ferguson, the case in which the Supreme Court in 1896 upheld laws that mandated the separation of blacks and whites so long as their respective facilities would be separate but equal. And of course, in 1954, the Supreme Court issued Brown v. Board of Education. In hindsight, it's amazing that Brown, the case that challenged public schools with stark differences on the basis of race, actually came to pass. South Carolina, for example, had a 1 to 28 teacher-student ratio for whites and a 1 to 47 ratio for blacks. The court heard the case during the 1952 to 1953 term, but couldn't agree on a decision, and punted it to the following year. Yet, in the interim year, Chief Justice Fred Vinson died of a heart attack. President Dwight D. Eisenhower appointed Earl Warren as the new Chief Justice. He convinced the other justices to unanimously rule that separate but equal in public schooling was unconstitutional. Note that the Brown decision was decidedly not originalist. Warren's opinion reflected the compassion and humanity and redefined black people as equal human beings rather than an inferior race. Supporters of segregation hated Brown, condemning it as a clear abuse of the judicial power. 96 Southern congressmen issued a declaration that the case climaxes a trend in the federal judiciary undertaking to legislate in derogatory of the authority of Congress. The Southern congressmen's attack on Brown encouraged states to defy the authority of the Supreme Court. Facing a stalemate, the Little Rock, Arkansas school system asked the court for authority to halt its integration plan. In a rare opinion signed by all 9 justices, the court said, "No, the constitutional rights of respondents are not to be sacrificed or yielded to the violence and disorder which have followed upon the actions of the governor and the legislature." In response, states began closing schools rather than integrating them, and doing so other things to get around Brown, like integrating only 1 school per year, so it would take decades to desegregate all schools. The Supreme Court hit back in 1964, declaring it unconstitutional for school systems to close rather than desegregate, and struck down other attempts to bypass Brown, including laws that allowed students a choice of schools, effectively keeping all white kids together. This gamesmanship only ended when Congress stepped up to the plate, enacting the Civil Rights Act of 1964, which prohibited discrimination by schools receiving federal funds. This legislation was followed by the Elementary and Secondary Education Act of 1965, which appropriated billions in funding for schools. With money in the mix, states finally began to fall in line. For the first time, the Civil Rights Act of 1964 also banned private racial discrimination that occurs with no government involvement. The statute covered racial discrimination in voting, in places of public accommodations such as hotels and restaurants, in public facilities, in public education, in publicly financed programs, and in employment. More legislation was passed, including the Voting Rights Act of 1965, the Age Discrimination in Employment Act of 1967, the Fair Housing Act of 1968, and the Age Discrimination Act of 1975. Because it had already discarded the 14th Amendment as a means of constraining private versus governmental behavior, the Supreme Court looked to other constitutional provisions like the Commerce Clause to uphold these laws. Despite Brown, racial segregation in schools has increased since the 1980s. In 2016, the U.S. Government Accountability Office reported that from 2000 to 2014, the percentage of high-poverty schools with 75 to 100% black and Hispanic students increased, while the number of minority students attending low-poverty, mostly white schools dropped. Although there are many possible explanations for this, the court's approach to the 14th Amendment is certainly one of them. As much as the Supreme Court pushed the contrary towards racial integration with Brown, it went backwards in cases that didn't involve laws that expressly discriminate on the basis of race. If a law is only subtly discriminatory with effects on racial minorities that don't spring from the plain language, it's extremely hard to do anything about it under the Equal Protection Clause. As I mentioned previously, there are 2 ways to show in court that the government made an unlawful distinction based on a suspect criterion such as race. Option 1 is available if a law uses language that discriminates against racial minorities, like laws mandating separate but equal schools for African American kids. Option 2 applies when a law is written in neutral prose but impacts race when it's put into effect. The problem with option 2 is that in order to win a case challenging a law's impact, a plaintiff also has to show that lawmakers intended to discriminate against black people. Not only is intent hard to prove, but in this day and age, most people who draft legislation know to avoid drawing blatant distinctions based on race or national origin, so option 2 is often the only one available anymore. The only time the Supreme Court upheld a classification under option 1 was in connection with the government's internment of 110,000 Japanese Americans during World War II. These Americans were taken from their homes and put into concentration camps to live in, horse stalls, and behind barbed wire, all on grounds of national security. The court upheld regulations of imposing a curfew on all persons of Japanese ancestry, an unequivocal distinction on the basis of race, on the rationale that they were defense measures for the avowed purpose of safeguarding the military area in question at a time of threatened air raids and invasion by the Japanese forces. In a recent decision upholding President Trump's travel ban, Trump vs. Hawaii, the Supreme Court finally condemned that case. The other issue with respect to option 1 is the area of affirmative action, the use of race to remedy past discriminations, enhance diversity, and foster positive role models for minority communities in college admissions, faculty hiring, contract awards, and the like. The Supreme Court has held that these justifications are not sufficient to satisfy strict scrutiny of review of racial quotas, meaning the setting aside of a specific number of seats for minority students, no can do to such affirmative action. However, colleges and universities can have a compelling interest in a diverse community, which justifies using race as one of many factors that can be used in admissions determinations. The court later held, in addition, that it's legally acceptable for universities to consider an applicant's race or ethnicity in admissions decisions when no workable race-neutral alternatives would produce the educational benefits of diversity. What might those race-neutral characteristics be? To achieve a diverse student body, therefore, students can legally consider things bearing on socioeconomic status, like median family income, adult educational attainment, home ownership rates, the number of single-parent households, the percentage of non-native English speakers, but affirmative action based solely on race is not allowed. Gender. As I mentioned already, gender classifications get what's called so-called intermediate scrutiny. What that means is that legislatures need a better reason than what comes off the top of their heads in order to pass laws that treat women differently from men because they are women and vice versa. But the intermediate bar is lower than strict scrutiny, so in the eyes of the Supreme Court, gender discrimination is more tolerable under the Constitution than discrimination on the basis of race or national origin. Prior to 1971, the Supreme Court upheld numerous laws discriminating against women, including laws forbidding women from becoming attorneys and laws automatically exempting women from jury service on the theory that a woman is still regarded at the center of the home and family life. The court explained in 1872 that the paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator. Women couldn't vote until 1920. They were excluded from the 15th Amendment, which was ratified in 1869 and granted from that right to black men, although, as with desegregation, that right was frustrated by things like literacy tests that made it all but impossible for formerly enslaved men to vote. In 1971, the Supreme Court struck down a gender-based law for the first time. The law expressly preferred males over females for purposes of determining who would administer an estate. Applying rational basis review, the court concluded that gender had no bearing on the ability to do that job. It was not until 1976 that the court came up with the intermediate scrutiny standard, however. The case involved an Oklahoma law that allowed women but not men to buy alcohol at age 18, the idea being that men drive drunk more often than women. Because it was justified by public safety, the law would have clearly passed on a rational basis review. But under intermediate scrutiny, the court held classification by gender must serve important governmental objectives and must be substantially related to those objectives. Traffic safety was an important government objective, but gender discrimination was not substantially related to that objective. Of course, what's important and what's substantially related are subjective questions that judges ultimately answer. In a particularly famous case, the Supreme Court applied intermediate scrutiny to find in 1996 that the exclusion of women from military academies was unconstitutional. The court reasoned that the male-only policy of Virginia Military Institute was based on gender stereotypes regarding the different talents, capabilities, or preferences of males and females. Federal military academies have integrated women with no problems, so Virginia was left with nary a leg to stand on. But since then, the results have been mixed around the constitutionality of gender stereotypes. In 1979, for example, the court upheld a law that effectively gave hiring preferences to veterans, 98% of whom were male. As with racial classifications, a law that doesn't expressly make distinctions on the basis of gender is hard to challenge. Abortion. While abortion may be one of our hottest button issues, to understand its legal precedents, consider a 1923 case called Mayer v. Nebraska, in which a teacher was tried and convicted for the crime of reading a German Bible to a fourth grader. The state of Nebraska has passed a law banning the teaching of anything other than the English language before the 8th grade. Reversing the teacher's conviction, the Supreme Court wrote that the salutary purpose of the statute is clear. The legislature has seen the baneful effects of permitting foreigners who had taken residence in the country to rear and educate their children in the language of their native land. The result of that conviction was found to be inimical to our own safety. In slapping Nebraska's overbearing hand, the court construed the word liberty in the Due Process Clause as meaning more than just hearing before government takes something as precious as liberty away. Mr. Mayor, after all, got a trial. As a matter of constitutional procedure, he could fairly go to jail. The court held that liberty captures something deeper. Liberty denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, and to worship God according to the dictates of his own conscience. How did this lead to Roe? Much like Nebraska could not jail people on the government's belief that the English language should be and become the mother tongue of all children reared in this state, Roe held that the liberty of a free person means that government cannot send a woman to jail for making a personal decision about ending a pregnancy on the rationale that the government thinks that decision is categorically wrong. Conservative scholars and judges take issue with whether the Mayer-Roe notion of substantive due process, the idea that government cannot take away certain rights, whether it affords a hearing or not, without a really good reason, which I mentioned earlier, is constitutionally legitimate. After all, the right to make decisions about your child's education is not laid out in the Constitution. But like the Bible or a poem, there are lots of things about our working Constitution that fall in this implied category that we would not want to do away with, regardless of our own political or ideological beliefs. In 1992, a so-called plurality asterisk, no one opinion got the agreement of a majority of the justices, although a majority did agree on the case's basic outcome. Of the Supreme Court in Planned Parenthood versus Casey upheld Roe, but took a huge bite out of it. For the first time, the court identified a government interest that can tip the scale against abortion, that is, the profound respect for the life of the unborn at any stage of pregnancy. Thus, the state can attempt to persuade pregnant women to choose childbirth over abortion and make it more difficult or more expensive to get an abortion, so long as it's not too hard. The court called this undue burden standard, and it's the reason why states can lawfully put restrictions on abortions, such as parental consent requirements and mandatory counseling or waiting periods, even if those requirements make it very hard for women, especially poor women, to reasonably exercise their constitutional right to choose an abortion. This is of critical importance to today's abortion debate. It means that courts can balance the right to an abortion with something else, something that belongs to the state, which is an interest in a fetus. And an argument can be made that the interest in potential life distinguishes abortion from the facts of Mayer. However, even if one agrees that a fetus is a manifestation of human life, that does not necessarily justify the government's unlimited ability to constrain a woman's pregnancy. A woman's life is a life too, and the government should care about it. And what does an undue burden mean? In Casey itself, the Supreme Court approved a law imposing a 24-hour waiting period, which is a serious problem for women in rural areas who have to drive hours or even days to get to a facility that performs abortions. States wanting to make an abortion illegal can keep trying new things to make it difficult to get an abortion, but not too difficult so as to violate Casey. The only way to know if something is too difficult for the Constitution is to litigate it all the way up to the Supreme Court. Sexual orientation. The Supreme Court has issued a number of decisions in favor of equal rights for gays and lesbians, without coming down one way or another on whether sexual orientation itself warrants a higher level of constitutional scrutiny. In 1996, the court declared unconstitutional a Colorado voter initiative that would have repealed all laws protecting homosexuals from discrimination. Recall that legislatures can pass laws that overlap with the Constitution. In the majority opinion, Justice Anthony Kennedy suggested that discrimination on that basis is inherently wrong, and questioned whether there was good enough reason for the law under any level of scrutiny. In dissent, Justice Antonin Scalia wrote an opinion arguing that sexual morality is justification enough for anti-gay laws. Justice Kennedy also wrote both of the decisions that culminated in a constitutional right to gay marriage. In 2013, the Supreme Court struck down federal but not state laws that interpreted the word marriage as only opposite same-sex unions. In his opinion, Kennedy suggested that laws discriminating against homosexuals should get some sort of heightened rational basis scrutiny if they were motivated by hate. But he did not firmly establish that sexual orientation is a category that gets strict or the highest or even intermediate or medium scrutiny. Then in 2015, Justice Kennedy wrote the opinion in a case that identified a constitutional right to marriage for gays and lesbians. Here again, Kennedy reached his conclusion without finding that gay and lesbians are a class that the Constitution especially cares about. He combined the due process right to liberty with equal protection because the laws burdened homosexual couples' liberty interest in marriage under the due process clause for discriminatory reasons. The equal protection clause was violated. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family, he wrote. The dissenters frowned upon the use of substantive due process as a concept at all. Recall that it derided by conservatives as quintessential activist judging. Chief Justice John Roberts reasoned in his dissenting opinion that preservation of the traditional definition of marriage was a sufficient basis to pass rational basis review. A few closing points on gay and lesbian rights under the Constitution. The court's decision to identify a right to gay marriage in the Constitution fastened on the institution of marriage, not on being gay. On the one hand, it was a progressive decision because it brought gays and lesbians into the official marriage tent, so to speak. The government now has to treat their marriage like anybody else's. But it didn't create a new category of people for which discriminatory laws get higher level of scrutiny. The decision is a ticket for that train only. The next case involving gay and lesbian rights, say, a state law permitting people to refuse to participate in same-sex wedding ceremonies, would not automatically get heightened scrutiny just because it targets homosexuals. The court would have to get at the issue some other way. In the case involving a Colorado baker's refusal to make a wedding cake for a gay couple, for example, the issue was framed around the baker's First Amendment right to freedom and expression, not around discrimination against gay men. What many people don't realize about that case is that the baker didn't actually win the core dispute. The court decided that the state-level agency that had first heard the couple's complaint had displayed hostility to the religious beliefs of the baker. The court thought that decision was unfair and sent it back to a do-over at the state level, passing the buck to Colorado for now. Immigration. Given the widespread anti-immigration sentiment in America, today it might surprise people that discrimination against non-citizens who are legally in the United States, sometimes called aliens, gets strict, the highest level scrutiny. The Supreme Court's rationale has been that the aliens are a discrete and insular minority for whom heightened judicial solicitude is appropriate. They cannot vote, they have no political clout, and are therefore highly vulnerable and unable to do anything about that through the electoral process. They need extra help from the courts to make sure that they aren't being subjected to abuse or arbitrary action by the political branches of government. Even for undocumented aliens, therefore, the Equal Protection Clause offers protections. Let's lay out some other constitutional basics regarding the power to regulate immigration and naturalization. Article 1, Section 8 of the Constitution grants Congress the power to establish a uniform rule of naturalization, which means that states can't grant citizenship. Early on, the Supreme Court wrestled with whether this means that the only Congress can deny people admission into the United States or remove non-citizens. Starting in 1889, the court made a few pronouncements on the topic that still apply today. First, it held that the admission of aliens is not a right but a privilege, and that the United States can prescribe the terms of admissions. Second, it concluded that the exclusion of aliens is a fundamental act of sovereignty, inherent to the executive power to control the foreign affairs of the nation, so it belongs to the president. Third, and a bit weirdly, the court reasoned that when Congress legislatures procedures regarding who gets to come into the country isn't just legislating, it's implementing an inherent executive power. Fourth, it held that courts can just review decisions to exclude aliens unless Congress specifically says they can. Also weird, because Article 3 of the Constitution gives federal courts the power to hear cases. How did we get from broad presidential power over immigration to a strict scrutiny standard for aliens under the Equal Protections Clause? The answer is that under the Equal Protection Clause, the issue isn't whether the rules governing admission, naturalization, and deportation are okay. The issue is whether it's okay that the other kinds of laws, state and local, treat aliens differently than ones that are in the country. Consider an Arizona law requiring that 80% of all employees be voters or native-born citizens, for example. The Supreme Court struck it down on equal protection grounds in 1915. There are a few exceptions to the strict scrutiny lens for people who are not United States citizens or nationals, which distinguishes the law regarding government discrimination against non-citizens from the law regarding, say, government discrimination against people of color. First, when it comes to the political process, states can call the shots and rational basis review applies. So, a state can deny non-citizens the right to vote, to hold political office, or to serve on juries. Second, Congress and the President can discriminate against non-citizens in ways that the states cannot, because together they wield a lot of power under the Constitution to control immigration. Non-citizens can be categorically denied federal Medicaid benefits, for example. But as I mentioned, strict scrutiny generally applies to non-citizens when it comes to a small category of benefits once they are in the country. States can deny non-citizens things like food stamps and Medicaid, but they can't deny undocumented persons who are in the country illegally a free public education or make them pay for it. In 1982, the Supreme Court rejected Texas's argument that such a law is justified in order to reserve government benefits for citizens, a rationale that would have surely passed rational basis review. A majority of the court was sympathetic to alien children who are not to blame for being in this country. The point of this view is significant in today's political climate. With the ideological shifts on the Supreme Court, the arguments put forth by Texas might prompt a different outcome if the issue were revisited. And that was Chapter 8 of How to Read the Constitution and Why by Kim Wehle.